Good morning. Happy Wednesday. I am here at the mediation site, at the office where we'll be conducting the mediation, 2 hours early. I am programmed to be up at the ass crack of dawn to open up coops and whatnot. So I've gone out to eat, I've fueled up the car, and now I'm just going to sit and wait. So I figure, why not take you guys along for a little journey into pleas. Pleas. As in, you can plead guilty, you can plead not guilty, you could plead an Alford plea, which is basically guilty, but I'm pleading innocence, or I'm pleading guilty, but I'm stating that I'm innocent, or no contest, meaning I'm not pleading guilty or not guilty, but I'm accepting that if this goes to trial, I'll most likely be convicted. So in Arizona, if you plead anything other than not guilty, you have to, it's rule 17 point something, maybe 17.3 or 17.4, I don't remember which, but the judge went over it. So like all you bright boys out there, you should understand this because the judge went over it. You have to show the court that you would or should or could indeed be convicted if it goes to trial. You have to. It is mandatory. For anything other than not guilty, you have to show the court that you would most likely be convicted at trial. That doesn't mean that you're pleading, that doesn't mean that you're saying that you are in fact guilty. You're just saying, because remember, a no contest is not saying I'm guilty or I'm not guilty. It's saying I'm not gonna plead anything. And you're never found innocent at trial. You can't plead innocent. It's guilty or not guilty or no contest. So one fine scholar in my comment section suggested to me that that Lane was trying to do an Alford plea. An Alford plea is where you plead guilty, but you insist that you're innocent. You say to the court, everything that the prosecutor can prove will prove by beyond a reasonable doubt that I, in fact, committed the crime. However, I am maintaining my innocence. Why would you want to do that? There's very, very limited cases where that's of any use at all that I'm aware of. I'm not going to research Arizona case law to find out if Arizona makes any real distinctions on it. And I did check to see if Arizona accepts Alford pleas, and Arizona does. But there is a caveat. No judge has to accept a plea of guilty, nolo, or Alford. No court has to accept that. The language in the rules of criminal procedure is may. I did double check that. The court may accept a plea, yada, yada, yada. And as we all know, apparently Lane doesn't, but as we all know, may is permissive, not mandatory. It's permissive. If you say, may I go to the bathroom, you are indicating that you are asking for permission to go to the bathroom. If the teacher or whoever says, yes, you may go to the bathroom, they have given you permission to go to the bathroom. They're not saying you must go to the bathroom. Lane's other that he used to contrast with it is someone saying I may or may not go to the beach. Well, that is indicating that you have the ability to go to the beach, not that you will go to the beach. So it's more akin to permission than being mandatory. There's nothing in there saying that you must go to the beach. I'm not really sure why he's trying to draw a distinction there, but he's definitely trying to draw the distinction. Regardless, may is always permissive. It is never mandatory. And the courts recognize that. Lawyers recognize that. Pretty much everybody but Lane recognizes that. And so the court may accept a plea. The court does not have to. The court is never bound to. And the court can consider whatever the court wants to in accepting a plea, as long as it considers the things that are required by the rules of criminal procedure. And I would assume that a court would treat a Alford plea approximately the same as a NOLO plea, no contest plea, for the purposes of a plea. The court would probably have to look at the they have to look at a few other things different than on a regular guilty plea. I think the court would probably have to treat an Alford plea almost as a no contest plea for that purpose. But that's just my guess, my supposition. Talk to a local attorney. I'm not licensed to practice law in the state of Arizona, so your mileage may vary. This isn't legal advice. So now that we've kind of understand that the court has to, if the court is going to accept a guilty plea, which would include a Alford plea, or a NOLO plea, which may include an Alford plea, the court must have facts established for it that would, if true, make the defendant guilty. Because the courts aren't in a habit of putting innocent people in jail, even if it's more convenient. If the court isn't satisfied that the facts would actually put the person in jail, the court has to say, no, you're just going to go to trial. And there's a reason for that. If you look back at the Alford case, it was Alford himself, the person who made the plea, who attacked the plea and wanted to have the conviction set aside. I don't remember all the reasons why. It's been forever since I've even looked at the case. It was something about he was charged like first-degree murder, and if he got convicted of first-degree murder, he would have got the death penalty, I think. He had prior convictions or something like that. He had a lengthy criminal record. So I think he was going to get the death penalty if he got convicted. But if he pled guilty... Did he plead guilty to a lesser charge? I don't remember. But if he pled guilty, then basically he would be guaranteed no death penalty. And so he pled guilty, but facts were established in that case that the court could use to determine that he would, in fact, be found guilty at trial. I don't remember how those facts were established, but I remember the facts were established that he would be found guilty, most likely, if it went to trial. And even though he was saying, I'm just pleading guilty because I don't want the death sentence, I'm actually innocent. Hold on. I think the facts that were established was that he said he was going to kill the dude. He left the house with his gun. I could be getting all these wrong, so double check me. The guy was killed, and then Alford returned with the gun and said that he killed the dude. I think those are the facts that were established when he pled. So even then, even then there were facts sufficient for the court to be like, yeah, okay, I'll accept your guilty plea. And that's what Alford was all about. And Alford attacked it later to try to set it aside. I don't remember if he got a life sentence or if he got a long sentence or what, but for whatever reason, he attacked it later to try to set aside the guilty plea. And it went all the way up to the Supreme Court. The Supreme Court said, no, it's fine. He could do that. You know, as long as he's fully informed, it's a knowing, intelligent, voluntary plea, especially with the assistance of counsel, you know, then the plea is good. So that was Alford. But let's go back to the hearing. Let's go back to what was going on at these hearings. If you listen to the judge said things like, you know, I won't have the prosecutor just rattle off the facts and have the defendant sit there silently. The defendant has to agree to the facts. So that whole hearing could have gone in an entirely different way. That whole hearing could have been just Stiles saying, on this date at this time he did this, it knowingly or it reasonably caused her fear, blah, blah, blah. On this date at this time he did this, it caused people to call, and harass her. He knew it would call and harass her, placed her in fear, blah, blah, blah. She could have rattled off the list of all of the allegations, the factual allegations, and he could have just said, yeah, I agree. Those are all the factual allegations, and I think that at trial, those would have been proven. But he didn't do that. That's not the way it went. Stiles was unwilling to participate in that fashion. I think, and this is just my opinion, I think that what she was saying was basically, F you. You know, you want to play big boy games. You want to pretend like you're an attorney. You want to pretend like you know the law and the procedure and everything better than I do. You go ahead and basically set up the plea deal. You state all the facts that are necessary. I'm placing the burden on you, Lane. And Lane failed that test. He absolutely failed that test. So the fact it could have gone different but didn't indicates to me that this was basically a shit test by Stiles. She's giving him a break. In her mind, you're saying, John, you're not a mind reader, but I've seen these kind of shit tests before. In her mind, she's going to win at trial. Obviously no guarantees, but you know, if she loses at trial, it's still no skin off her nose. She gets paid the same either way. But I think that she thinks that this case is a slam dunk. I think Lane's elbow counsel also thinks the case is a slam dunk for Stiles. I think Lane's prior attorney, Parvin, thought it was a slam dunk for Stiles. And his only hope was like a maybe kind of First Amendment appeal for vagueness, but that wasn't going anywhere. And I don't think he thought it was going anywhere, but he could have made a good argument, right? He could have had his name on another appeal. So it's a shit test. And I would also bet, I couldn't really hear the victim's testimony about it, but I gather that she wasn't terribly thrilled with the deal, that she wanted to make sure that he admitted guilt, and that, you know, and that provisions would be put into place where he wouldn't be able to harass her again without some serious repercussions. And so my best gut intuition is that the deal was that Lane Myers plead guilty, not an Alford plea, not a no-low plea or a no contest plea, but a guilty, straight up guilty plea. Why would they do that? Well, on an Alford plea, well, on a no contest plea, you're not admitting to guilt. You're not saying I did it or I didn't do it. You're just saying that I get it, you could prove it, I'm not going to contest it. But the issue is that Lane Myers has supporters out there who are still doggedly in this, who are still sending emails, sending letters, doing all sorts of things on his behalf. And they want that stopped. This is my gut. This is my gut. So, again, all this with a grain of salt. If he did the Alford plea and he maintained his innocence, then that wouldn't cut everything off. If he did a NOLO plea and he didn't say I'm guilty or not guilty, that wouldn't cut everything off. But if he says in open court, I did this, I was wrong, it was a crime, I had no justification for doing it, they know that his supporters are going to hear that. And I'm sure they're hoping that this is going to get some of the supporters to back off. It's gonna crumple Lane Myers' persona, which I have no idea why he has it. I don't know why anyone would believe a word that comes out of his mouth, because he was fucking perjured again in court yesterday. Where's the video about the 33 lies that Lane Meyer did on his motion to recuse? It just baffles me that there is zero charity for anything that the victim says or the state's witnesses say, but there's limitless charity for everything that Lane Myers says. See, I get it. I know what happened. Lane Myers heard a thing, but it gets filtered through his brain fog, and so he remembers what he thought someone said, not the words that came out of their mouth. Most people work that way. They don't hear what you say, they hear what they think you said. And it's a night and day difference. And you'll figure this out by doing depositions and by doing examination of witnesses on the stand, because you'll ask a very specific question and you'll get an answer to a completely different question that you didn't ask. All the time. Most people don't hear what you say, they hear what they think you said. So anyway, going back. So the plea agreement is a contract that they would have had between Stiles and Myers. Notice Stiles didn't sign it. Myers did. No, I think she did before she gave it to the judge. But Myers signed it first. But anyway, so this plea agreement would have set out what he had to plea and the various things that he had to do in order to get basically the state to drop the 12 out of the 14 charges, right? And my best guess is that as part of the plea, he had to plead guilty. Not an Alford plea, not a no contest plea. He had to plead guilty to those. Almost, I would say I'm 66.66% certain that that's the language that was in that plea agreement. That it was for a guilty plea. Not an Alford plea, not a no contest plea, but a guilty plea. And that he would have to admit guilt. I'm 50% sure. I mean, that's a coin toss that it said that he had to actually admit guilt, because they basically would get him to admit guilt by making the guilty plea and then going through the list of things, the elements of the crimes that he was pleading guilty to you'd give them what they needed by doing that. So it's a toss up on whether or not. But anyway, my point is that if Lane Myers was trying to do an Alford plea, well, that wasn't the plea deal, and he didn't know how to do it, and he still had to basically give the court all of the elements of the crime and say that they were satisfied in order for the Alford plea to go through. That's statutory. He can't get around that. So telling me that he was trying to do an Alford plea, like, you're just basically saying that he's so fucking inept that either A, he doesn't understand what's in the plea deal, or B, he doesn't understand that even with an Alford plea, he still has to give the court justification that he'd lose going to trial. Reason to believe, facts that he'd lose going to trial. And he didn't understand that. So if you're saying that he was trying to do an Alford plea, you're just confirming that he's fucking inept. He's just fucking inept. Speaking of inept, another guy made a comment that I was driving yesterday without my seatbelt on. Now, I don't know if you could tell, but I'm wearing a seatbelt right now. I've been wearing a seatbelt this entire conversation that we've had in the car here. And I did it just to prove a point. Even though I'm parked, I did it to prove a point that Lane Meyer supporters are so stupid that if they can't see something, they assume it doesn't exist. Wow. Like, who drives a modern car that doesn't ding at you just incessantly? Now, I admit it, my car's a 2018 Ford Fiesta. Fine car. Fords make fine cars. But yeah, it dings at me if I don't have my seatbelt on. So you could be pretty sure I had my seatbelt on. And also driving for 4 hours with the number of cops that go up and down 99. Yeah, I'm pretty sure I had my seatbelt on. I'm pretty sure. But maybe you're smarter than I am. And maybe because you didn't see it on the video, maybe I didn't have my seatbelt on. Maybe you're just that fucking smart. God, I love Lane Meyer supporters. They are stupid to the point of hilarity. Anyway. That burned up 20 minutes. Now it's like 7:30. Still got a lot of time. I might go for a walk. Thanks for watching. Have a great day.